having dealt with the fiduciary duty, right, that's the one about dealing with whether or not you're being dodgy, whether you're acting for yourself or for the company. So the primary thing there, act for the company, not yourself. The second area where you have a general duty is different in that it focuses on whether you've exercised care and diligence, whether you've been, for want of a better kind of thought, whether you've been negligent or not. Okay. So the idea here is that in addition to not being dodgy, you also have to be applying yourself appropriately as a director. And that's where due care and diligence actually comes from. For a lot of convoluted reasons that I won't go into, it has a history as a fiduciary duty, but it's really a different kind of thing that the law is looking at. It's looking at what you actually did and whether you applied yourself. So let's have a look at the particular piece of legislation. We can see that it's under section 180 subsection 1. And it says that a director or other officer, again notice we capture officer, must exercise their powers and discharge their duties with the degree of care and diligence a reasonable person would. Okay, so what does that mean? Again, it's our reasonable person test in the law. It's objective. It's not what did the director think, it's what a reasonable person would think if they were a director or officer of a corporation in the circumstances. So of course, we would expect more of a director of BHP than, say, the local knitting club. Okay, so the company's circumstances actually matter. What also matters is the office held by the director or officer. Okay, so what particular role did the individual director or officer play? That's going to affect the reasonable person's view of what they should be doing. So while this test is always the same, it's a reasonable person test, the actual standard can vary from situation to situation based upon the company and the position of the individual involved. So this is a reasonable person test, which brings us back to the idea of the famous legal jurisprudence put it, the person on the Clapham omnibus. What would an average person with no special training who takes public transport to an ordinary suburb, what would they expect of a director in these particular circumstances? For a period of time, people got a bit worried about whether this duty was rising too much, and we can discuss that together face to face, but I won't go into the details of why that occurred. As a result of that, lawyers and the government started looking at putting in a defence for due care and diligence. How do we know that you've taken enough care and diligence in what you do? And that's where we get section 180 subsection 2, the business judgment rule, which is a defence to due care and diligence. Okay. So what does it actually say? It sets out that you meet the requirements of subsection 1, that is due care, okay, because this is subsection 2 of 180. You meet your due care requirements and their common law and equity requirements if you make the judgment in good faith for a proper purpose. Notice that's fiduciary duty again. Do not have a material personal interest. Fiduciary duty again. This is our kicker. Inform themselves about the subject matter to the degree they reasonably believe to be appropriate. Okay, so that means you have to pay attention to what's going on. And you rationally believe the judgment's in the best interests. Okay. So this kicker here is that you've got to inform yourself to pay attention. Now, this defence hasn't been used very often for a number of reasons. One is that most people charged with something often have a problem with this good faith, with this fiduciary duty, and so they fail on the defence there. Very recently, the Mariner case did successfully use the business judgment rule, the directors in that case, and informing yourselves is actually subjective. Did the director think that they needed to inform themselves? To what degree? So again, that provides a fair bit of latitude and solace to directors in that defence. Importantly though, the legal developments in this area have essentially said you need to be more questioning of experts, and really I think even more than experts, it's the underlying assumptions in your decision making. So in the Vines, Hardy and Centro cases, what you tended to have was not only reliance, but essentially blind reliance as directors. And the law doesn't really like that. You have to be able to show that you thought independently, okay, about the issues. Sometimes when we request a consultant's report, we get the answer that we want rather than a sensible answer. These kinds of cases are saying, hey, the law might expect a little bit more of you as we move into the future. A second key area of law, I also said that there was a third area, everything else. Obviously, we can't cover every other legal area, every other legal duty required by legislation. But in this particular slide, what you can see is that there's a whole raft of these. Not only is there a whole raft of these, but they're going to vary by the context of your company. So for instance, if you're a mining company, you're going to have different legal requirements on you than one who isn't a mining company. So directors really need to be able to understand what the most important ones of those are and what risks they face as a result of their position and what the law requires of them. In terms of other duties, next module we're going to look at this insolvent trading, which is an important one. So I won't go into much detail about that. I also did note that there are a whole series of other duties that can be required under the Corporations Act. If you're a listed entity, so if you're on the stock exchange, continuous disclosure becomes important. For most public companies and all public companies, again, we see the impact of the fiduciary duty with the disclosure of related party transactions and directors' interests. Whole raft of legislation that we've already dealt with. Now, one question that comes up is, do all directors owe the same duty? Well, the roles are the same, whether you're an executive or non-executive, whether you work full-time or whether you're a part-time director, but the test is what a reasonable person would expect. So what we can see here is that I think a reasonable person would expect a full-time employee to know more about and work harder at the decision than a part-time employee. So the test is the same, but the standard is going to vary. And where we often see this is really in how the penalties are applied in courts too. You tend to see the executives being penalised a lot more than the non-executive directors. And we can go over the Greaves case as an example which shows the thinking of judges around this particular test. Now note, while you do have this duty, you can delegate your powers, okay? But you need three conditions. You need to minute it, so it must be approved by the board in the appropriate way. You must have checked the person out, right? Because there's got to be reasonable grounds to believe that they could do it, that they were reliable and that they were competent. And you must also be able to say that in an ongoing basis. So while there's 4 dot points, there are probably 3 things to do. Minute it. 2, check the person out, right? So that's really good HR. And the third thing that you actually need to do is to do an ongoing monitor. So that if you get a red flag that the person's not doing their job, you can jump in and act, because that could be a signal, right, that they're not going to act in the corporations, even if you checked them out previously. So it does mean you need to bring your mind to what's going on in the corporation. Notice it just provides you a bit of a defense. Okay? It doesn't excuse you of the duty, but you can say that you delegated appropriately. You also can't delegate some duties because the Act requires it. And that's what happened in the Centro case. There was a specific section of the Act that said directors must. Well, when the directors didn't even read the financials, then the judge said, well, you know, you really can't delegate this because it says you must. You could have delegated the advice, right? But you actually have to read it and make the decision yourself. So these legal aspects that we've been dealing with then spill over into expectations in the Code of Conduct. So here is the Australian Institute of Company Directors Code of Conduct. And if we go through it, what can we see? We can see reference to the fiduciary duty, due care and diligence, proper purpose, fiduciary duty, primary responsibility is to the shareholders, that's who we owe our duty to, improper use of information, fiduciary duty, improper advantage, fiduciary duty. So I'll leave you to go through it, but you can essentially see that these core duties that we went through lie at the heart of the expectations of directors.